This presentation is on our consultation paper, Getting Married, a consultation paper on weddings law. We published the paper on the 3rd of September and we're now running a public consultation that continues until the 3rd of December. I'm Nick Hopkins, the Commissioner for Family Law, and I'm joined in this presentation by Professor Rebecca Probert, who is a specialist consultant working on the project, Elizabeth Welsh, the lawyer on the project, and Sam Hosseini, who is the research assistant on the project. This presentation is designed primarily for members of the public, particularly couples who are interested in the work that we are doing. And so it looks at areas that we think would be of particular interest to couples, including how a notice of marriage is given, the rules governing where weddings can take place and the content of ceremonies, how weddings are registered, and the validity of marriages and the consequences when couples do not comply with the legal requirements. If you've not come across the Law Commission before or aren't familiar with who we are and how we work, we're an organisation that was created by Parliament back in 1965, and we were set up by Parliament in order to keep the law of England and Wales under review and to make recommendations to Parliament for reform. We work independently from government and we receive our funding for projects only from government. For all of the projects we do, we agree a set of terms of reference with government and we then work within those terms of reference independently. Our job is to make recommendations for how the law is reformed. It is then up to government to decide whether and how to take those recommendations forward. But historically, around 2/3 of our reports have been implemented in whole or in part. If you want more information about our relationship with government, then you will find our protocol with the Lord Chancellor and the Welsh Ministers on our website. So for this project, our terms of reference require us to look at the law relating to how and where people get married. What we are aiming to do is provide couples with greater choice within a simple, fair and consistent legal structure. And so in order to do this, we're looking at all of the stages, all of the legal stages relating to getting married, from how you give notice of your ceremony through to when you register your marriage. And our review is governed by a number of principles for reform. We want the law to be certain and simple. We want it to be fair and equal. We want it to protect the state's legitimate interests around weddings. So, for example, the state's interest in knowing whether a couple are married and in providing protection against forced and sham marriages. We want to enable individuals' wishes and beliefs to be reflected in how they get married. And we want to remove any unnecessary regulation so that we can increase choice and lower the cost of wedding venues for couples. So our terms of reference look at the full legal process of getting married. So starting with what preliminaries are required. So by preliminaries, we mean how do you give notice of your wedding? Then looking at where a wedding should be able to take place. And one of the things we want to do in our reforms is enable weddings to take place in a much greater variety of venues. For example, we ask if weddings should be able to take place outdoors, which is not generally possible at the moment. We look at who should be able to solemnise a civil or religious wedding. And we've been asked to ensure that the scheme that we put forward could allow weddings by non-religious belief organisations such as humanists and by independent celebrants. The prior question as to whether non-religious belief organisations or independent celebrants should be able to solemnise weddings is not, however, part of our review. We then look at the content of a wedding ceremony. So, for example, should there be specific vows that couples are required to give? And then how marriages are registered and what the consequences should be if any of these formality requirements are not complied with. There are a number of matters that are excluded from our terms of reference. So in other words, these are issues that we will not be considering during the review. They include eligibility to marriage. So for example, the age at which people are able to get married. The ability of religious groups to not solemnise same-sex weddings if they do not wish to do so. That's protected under the current law and would continue to be protected under the scheme we put forward. The duty of the Church of England and Church in Wales to marry parishioners, which will be the same under our scheme. The rights and responsibilities of parties who are married, divorce and what happens when a couple separate or divorce, the recognition of foreign weddings, so that the recognition in England and Wales of weddings that take place overseas, and finally ancillary wedding services. So for example, we're not looking at disputes or issues that may arise where a couple have entered into a contract for the caterers for their wedding. So looking at the provisionally proposed scheme that we are consulting on, we believe that it has a number of advantages over the current law. We consider that it will replace the outdated and overly restrictive current law of weddings, much of which dates from 1836. By doing so, it will make the law fair, simple and certain. A key feature of our proposed scheme is that it regulates weddings according to the officiant, the person responsible for certain aspects of the wedding, rather than regulating weddings according to the location in which the wedding takes place. And it will also apply the same rules to all types of weddings as far as possible, with just a few exceptions. So I'm now going to hand over to Sam, Elizabeth and Rebecca, who are going to take you through some of the key aspects of our proposed scheme.
Thanks very much, Nick. Before going through our provisional proposals in a little more detail, we just wanted to show you this graphic. Depending on the size of your screen, it might be a little bit small. It's also available at full size in the consultation paper and in the summary document, both on our website. The graphic shows our proposed scheme from the point of view of the couple. It shows the steps that they must take to be married, or the path to marriage. As currently, the process is divided into 3 stages: preliminaries, the ceremony itself, and the registration of marriage. However, the requirements for each stage will be simpler under our proposed scheme. Couples will be afforded more choice, and with few exceptions, the same rules would apply to all marriages. In this presentation, we're going to go through the law governing preliminaries, the ceremony itself, including who is required to be there and the location of the ceremony, and the validity of weddings. We're going to outline some of the concerns with the current law and our provisional proposals. First, looking at preliminaries, sometimes called giving notice. Under the current law, preliminaries are divided into 2 alternative processes. Civil preliminaries, mainly conducted by local authorities, which can authorise any type of wedding, and Anglican preliminaries, which can authorise weddings in the Church of England and Church in Wales. First, looking at civil preliminaries. Put quite simply, the process currently is that couples must live in the registration district in England and Wales for 7 days before they give notice of their intention to marry at the register office in that district. There's then a 28-day waiting period before they can get married. During that waiting period, the notice of their intended wedding is required to be published at that particular register office in what the Marriage Act calls a conspicuous place. There are several concerns about the current process for civil preliminaries. For starters, the rules make it very difficult for people who are resident outside of England and Wales to get married here. Couples must either make a trip of at least 7 days to England and Wales to give notice, followed by another trip to get married at least 4 weeks later, or they have to make a single trip of at least 5 weeks, both to give notice and get married. The rules are also inconvenient for couples who do reside in England and Wales, because they mean that they might not be able to give notice in the district in which they work, and if the two members of the couple don't live together, they might not be able to give notice at the same register office. We've also heard that notices of intended marriages are rarely read by anyone, and in our discussions with stakeholders so far, we've not heard of an objection to a marriage ever being made solely on the basis of a notice being published. So what do we propose? Well, we make a number of provisional proposals for reform. First, we propose to abolish the requirement to live in a specific registration district in England and Wales for 7 days prior to giving notice. Second, we propose a two-stage process for giving notice. At the first stage, it will continue to be possible for each person to submit their notice of intention to marry at the register office, but they would also have the option of submitting their notice by post or online. Submitting the notice would start the 28-day waiting period. Then at the second stage, individuals who had given notice online or by post will be required to attend a register office for their in-person interview. Individuals would have the choice of which register office in which registration district to attend, and the interview will be an opportunity for impediments to be discovered and registrars to address concerns around forced and sham marriages. We asked consultees how far in advance of the authority for the marriage going ahead, which will be called a schedule, being given, the couple should be required to attend their interview. We asked whether it should be 3 days, 7 days, or another period of time. We also proposed that notices of intended marriages should be published online. Together, we think these changes will bring some important benefits. Allowing the first stage of the process to be done online or by post will bring the process into the modern day. It'll be more convenient for couples, and it could be more efficient for local authorities. Together with abolishing the requirement for 7 days of residence, these proposals will also facilitate weddings in England and Wales of couples who are resident elsewhere, and that in turn could bring economic benefits. Finally, publishing the notices of intended marriages online will increase the likelihood of impediments being discovered, and it will promote the public nature of the process. Turning now to Anglican preliminaries. Currently, couples who get married in the Church of England or Church in Wales can give notice to the church authorities instead of giving notice at the Civil Registration Service. There are 3 types of Anglican preliminaries. First, the publication of banns, and then common licenses and Archbishop special licenses, both of which are issued by the church authorities. We think the rules governing Anglican preliminaries are complicated, they're no longer effective, and they stand in contrast to civil preliminaries in important ways. Banns are the most common type of Anglican preliminaries, and they involve the reading out of a notice of the intended wedding for 3 Sundays during a church service. The rules governing banns are very complicated, and they span about 13 sections of the Marriage Act. Banns may be required to be published in up to 3 different churches. We think that banns are ineffective because with fewer people attending church services and a more mobile society, it's less likely that publishing banns will reach an audience who actually know the couple intending to get married. Common licenses and special licenses don't require any sort of publicity at all. Those licenses are also unique in that they allow a wedding to go ahead without any waiting period. Finally, there's no requirement for the clergy person conducting the preliminaries to meet both members of the couple, and they have no power to call for documentary evidence apart from requiring evidence of nationality. Now on this slide, we're looking at the options for reform, and we consider two options in the consultation paper. The first is to move to a system of universal civil preliminaries. We ask consultees whether Anglican preliminaries should continue as legal preliminaries to weddings, or if instead universal civil preliminaries should be introduced, meaning that all weddings would be preceded by giving notice at the register office. Under such a system, bans could continue to be published, but they would no longer provide the legal authority for a wedding. In the alternative, we provisionally propose that if Anglican preliminaries are retained as the legal authority for weddings, redundant provisions should be repealed, for example, concerning the publication of bans where a church has been damaged by war. We ask consultees whether bans should be required to be published only in the church where the wedding is going to take place, to simplify the process and prevent duplication. We also ask questions about whether Anglican clergy should have the power to call for and check documentary evidence from the parties, and whether they should be legally required to meet and get declarations from both of the couple. I'm now going to hand over to Elizabeth.
Thanks, Sam. We now move on to the rules governing the wedding ceremony itself, starting with the rules about who is responsible for attending the wedding and registering it. So one significant issue with the rules is inequality. So under the current law, there are different rules for the different categories of wedding that are identified in the Marriage Act 1949. Those are Anglican weddings, Jewish and Quaker weddings, all of the religious weddings, and civil weddings. So for Jewish and Quaker weddings, although there are rules about who must register the marriage, the law does not require that person to attend the wedding. Conversely, for all other religious weddings, a religious leader or another person authorized to register the marriage must attend and register it. And for civil weddings, two registration authorities, a superintendent registrar and a registrar, must attend. The current law also suffers from a lack of clarity. So in addition to the different rules about who must attend, there are different rules which govern what that person must do. So most consistently, as we've seen, that person is required to register the marriage and also in most cases to attend the wedding. However, in some cases, the person has additional roles. For example, Anglican clergy are also required to solemnize the marriage by the Act. The current rules also suffer from unnecessary regulation, and in particular is the requirement for a registrar and a superintendent registrar to attend all civil weddings. This requirement increases the cost for local authorities and for couples and limits the availability of civil weddings at popular times, such as during the summer. In our consultation paper, we make provisional proposals for a new system that would rationalize these requirements. Under the scheme that we propose, there would be a new role of an officiant. And under the law, all officiants would have the same legal duties and responsibilities, and all weddings would have to be attended by one. The focus of the regulation would be on this person and their responsibilities. So all officiants officiating in a wedding would have a duty to ensure that the parties freely express consent to marry each other, that the other requirements of the ceremony were met, and the schedule was signed. Officiants would also be responsible for upholding the dignity and solemnity of marriage. In our consultation paper, we propose that there would be up to 5 categories of officiants. Now, the number would depend on decisions made by government as to whether non-religious belief organizations and independent celebrants would be authorized to conduct legal weddings, a point on which we are not making recommendations. So the first category would be registration officers, and as now, they would be appointed by local authorities. They would conduct civil weddings. Under a provisionally proposed scheme, they would no longer attend religious weddings, and only one would be required to attend a civil wedding. Anglican clergy would be the next category. Clerks and holy orders of the Church of England and the Church in Wales would be automatically recognized as officiants, and they would conduct Anglican weddings. Next category is nominated officiants. So these individuals would be nominated by religious organizations other than the Anglican churches to conduct religious weddings. And if non-religious belief organizations were authorized to conduct legal weddings, then they would also be able to nominate their celebrants to conduct non-religious belief weddings. In the next category is maritime officiants. So under a proposed scheme, they would conduct civil weddings in international waters on board certain types of vessel, namely cruise ships, and they would be required to be a senior officer on board that ship. And the final potential category is independent officiants. So this category would only exist if government decided to enable independent celebrants to conduct legally binding weddings. But if they did, these celebrants would be able to apply directly to the Registrar General to be authorized as independent officiants who would conduct civil weddings. Now moving on to the content of the ceremony itself and concerns that arise in the current law. So first is the different treatment of different groups. Again, there are different rules depending on the category of wedding. So for example, civil weddings and religious ceremonies other than Anglican, Jewish, and Quaker ceremonies must include the couple saying exact prescribed words, that they declare that they are free to marry one another, and the words of contract. Conversely, Anglican, Jewish, and Quaker weddings do not have to include these prescribed words. Rather, the legislation requires that these ceremonies take place according to the rites of those groups. There is also concern with the current law in relation to the restrictions on civil weddings, that is specifically the rule which prevents religious content in civil ceremonies other than incidental religious references. This rule does not reflect the beliefs of many couples we have heard who wish to include content that has religious or cultural meaning to them in their civil ceremonies. Finally is the rule about open doors under the current law. So the Marriage Act 1949 requires that some weddings take place with open doors or with free public access. But this requirement, again, only applies to some weddings. It applies to civil weddings and it applies to religious weddings other than Anglican, Jewish, and Quaker weddings. But in our work with stakeholders to date, we have not heard that it is serving a clear purpose. For example, we have not heard that it gives rise to valid objections at the ceremony. Moving on to our provisional proposals. As we explained in the consultation paper, under a proposed scheme, the same legal rules would apply to all groups and so to all types of wedding. Our scheme also does not regulate the content of ceremonies more than is necessary in order to give couples and religious groups freedom over their ceremonies. In our proposed scheme, the core requirement of each wedding ceremony would be that each of the couple express their consent to be married in the presence of each other, the officiant, and 2 witnesses. But there would be no requirement that the couple express their consent in any particular way, and indeed consent could be expressed non-orally. And we think that this would accommodate the many ways in which people show their consent to be married, particularly in the variety of religious ceremonies that take place. Of course, however, religious groups could continue to impose their own requirements about the ceremonies they conduct, which would include whose weddings they will conduct and the content of those ceremonies. So our provisional proposal would not require religious wedding ceremonies to change. We also provisionally propose that religious content would be permitted during civil ceremonies, except the ceremony will be required to be identifiable as a civil ceremony rather than a religious service. And we ask whether the legislation should expressly state that certain things would be permitted, such as hymns, religious readings, and imagery and songs in civil weddings. And finally, we provisionally propose that there be no requirement for open doors. Now turning to where weddings can take place. So the current law is often described as a building-based system, and in that system, most weddings have to take place in a building that is a place of worship that has been registered for weddings, or in a register office, or on premises that have been approved for civil weddings. However, some types of weddings are excepted from these rules. Jewish and Quaker weddings can, as a matter of the civil law, take place anywhere, allowing those groups to themselves regulate where their weddings can take place. There are also distinct rules for Anglican weddings. Although most Anglican weddings must take place in a public church or chapel, a wedding authorized by special license could, as a matter of the law, take place anywhere. However, as we understand, the Archbishop only issues such special licenses for weddings in places of Anglican worship, for example, in private college chapels. So the rules under the current law limits couples' choice. For example, most couples cannot marry outdoors, they cannot marry in a private home, and they cannot marry in waters, in territorial waters or at sea. And many of the weddings that take place outside the current framework do take place in a much wider range of places, which shows the demand of couples to get married in a more a wider variety of places than the current law allows. The rules also do not work well for some religious groups. For example, some religious groups, particularly small religious groups or interfaith ministries, tend not to have their own buildings in which they conduct weddings. For other religious groups, their place of worship is not seen as a meaningful place for them to have a wedding, and we understand that this is the case for some Muslim groups, for example. The particular rules around civil weddings also drives costs. So other than register offices, civil weddings must take place on approved premises, which are premises that are approved by the local authority. And approval usually requires a fee, and our initial research suggests that local authorities charge a median fee of approval of about £1,500. And this cost can prevent businesses which only host a few weddings a year from being able to be approved and so to host civil weddings. In our consultation paper, as we explain, our proposed scheme focuses on the regulation of the officiant, and that would give greater freedom about where weddings could take place. So under our proposals, weddings would be legally permitted to take place anywhere, and that would include outdoors or in private venues such as a home or on a military site and on inland, coastal, and territorial waters. There'd be no requirement for venues to be pre-approved by government, and that would reduce unnecessary bureaucracy. However, we do ask whether civil weddings should be prevented from taking place in religious places of worship. Well, under our proposed scheme, for a wedding to take place in a given location, the officiant officiating at the ceremony would have to agree to that location, and the officiant would be responsible to consider the dignity and safety of the venue in agreeing. This approach, we think, would increase choice for couples, allowing them to get married in a location most meaningful to them. Increased choice would also open up lower cost options like getting married at home or in small community venues, and it would also drive competition among commercial businesses. Under our proposed scheme, religious and, if they were enabled to conduct legally binding weddings, non-religious belief organizations would of course be entitled to insist on their own requirements about where weddings could take place, such as requiring that a wedding take place in a church, a chapel, a meeting house, or a gurdwara. Religions could therefore continue to only conduct weddings in their own places of worship if that's where they wished. In a consultation paper, we also consider whether there should be an optional scheme for pre-approval, and if there were, some venues would already have been determined to be safe and dignified, which would remove any need for an officiant to make their own assessment of safety and dignity, and we think this scheme might be most useful for registration officers. I now pass it over to Rebecca.
Thank you, Elizabeth. So this graphic, which is also available for a closer look in the consultation paper and summary, shows the rules that would apply to all weddings based on the different type of officiant who'd be required to attend. And it shows that with few exceptions, the same rules would apply to all. Now, in requiring certain formalities for a wedding, the law must also consider what the consequences are if a couple fails to comply with those formalities. So we turn now to the law governing validity. The general policy of the law in England and Wales has been to uphold marriages wherever possible. Nevertheless, not all weddings will result in a valid marriage. A marriage can also be void or voidable, or the ceremony may not qualify as a ceremony of marriage at all. The current law and the consequences of a failure to comply with the formality requirements in terms of validity are far from clear, and different rules apply depending on the types of wedding. First, the validity rules are different for different types of wedding. This means that it might be easier for a wedding by one religious group to be recognised by the law than another. Second, there's a lack of certainty about the minimum required for a valid marriage. Only certain failures will result in a marriage that's void. These are all spelt out in the legislation. However, the Act is silent on the consequences of other failures, for example, not having witnesses. The implication is that these have no consequence in terms of validity, i.e. a marriage will be valid even if it's not attended by two witnesses. But most fundamentally of all, the provisions of validity do not address what happens when a couple has not complied with any of the requirements. Over the years, the courts have developed the concept of a non-qualifying ceremony, what was previously called a non-marriage. The courts have said that there's a bare minimum required to bring a wedding within the Marriage Act and ensure that it has legal consequences. but the law does not specify what those minimum requirements are. As a consequence, some couples have weddings that they believe are legally recognised, but which in fact have been categorised as non-qualifying ceremonies. And this is creating hardship. Unlike the parties to avoid marriage, parties to a non-qualifying ceremony cannot apply to the court for financial provision. We understand that this issue is more common among couples who marry according to certain religious traditions, including Islam. So our provisional proposals aim to make it clear when a marriage will be valid or void. They also aim to reduce the number of weddings that will be non-qualifying, particularly when the couple believed that their wedding would be recognised under the law. So this flowchart, which again is available in the consultation paper and summary, shows the consequences under our scheme in terms of the validity of the marriage for the couple, should they fail to comply with the required formalities. We propose that each of the following would make a marriage void. First, the failure of both or either of the parties to give notice of their intended marriage to the registration service, or, if Anglican preliminaries are retained, to the relevant church authority. Second, the wedding taking place after the authority to marry had lapsed. Third, the knowledge of both parties that the ceremony was not officiated by an authorised officiant. And fourth, in the case of same-sex marriages, the knowledge of both parties that the necessary opt-in to same-sex marriage had not been given by the relevant religious governing authority. In some circumstances, a wedding would be non-qualifying, meaning that it would not be recognised by the law at all, and financial remedies could not be awarded on the breakdown of the couple's relationship. But ceremonies would only be non-qualifying under our scheme if either couple did not consent to be married, or where the couple did not give notice and both did not think that they had an authorised officiant at the ceremony. In these types of cases, we think that reform to cohabitation law could best protect these couples, and the Law Commission recommended reform to cohabitation law in 2007. Finally, our scheme looks at the impact of COVID-19. The COVID-19 pandemic has had a significant effect on weddings. For a time, virtually all weddings had to be cancelled or postponed due to the public health laws which came into place to limit the spread of the virus, with only a few weddings being able to take place where one of the parties was terminally ill. Now, our project is not considering the issues which can arise if a wedding is cancelled in terms of disputes between venues and other vendors and couples about refunds. Nor can our project make recommendations that would allow a wedding to take place in person if public health rules did not permit it, or about if and how wedding receptions should take place when there are public health regulations in place because of a pandemic. However, what our project can do is consider how the legal requirements of a wedding ceremony could be met, so that a couple can become legally married during a future national emergency such as a pandemic. Our provisionally proposed scheme already offers some advantages which could allow weddings to take place, for example by allowing weddings to take place in a couple's home or outdoors. We also make a provisional proposal for a power which could be exercised during a future emergency to facilitate weddings taking place. Such a power could extend the validity of existing schedules, that is, the authority to marry, so that they don't expire when a wedding has to be postponed. This would prevent couples from having to give notice again. It could also allow both stages of notice to take place online. This would allow the in-person meeting stage to take place online over an app like Zoom or Skype. It could even allow ceremonies to take place online by a video conferencing app. This would allow a wedding ceremony to take place when restrictions prevent anyone from travelling or from people from gathering together, including if a person was self-isolating. Each of the couple, the officiant and the two witnesses could be in different locations, but would all watch and participate in the ceremony over an online video app. Finally, it could allow registration to take place by post or electronically. This proposal could allow for different versions of the same schedule to be created and all those in a different place to sign their version and send them in to be registered, or we could allow everyone to sign the schedule online electronically. So what's next? Our public consultation will run until 3rd of December 2020. We will then conduct an analysis of the responses to our consultation and formulate our policy. And our final report with recommendations for reform will be published in 2021. So we very warmly encourage you to respond to our consultation, and all the details about how to do so are available on our website.